So welcome everyone to this webinar. I'm Rafael Carmona from the ICDR, and on behalf of the ICDR Young and International Group, I want to thank you all for attending this webinar. I want to thank our panelists, our moderator, Santiago Peña, and I want to, before we commence, take a moment of your time to remind you that if you're not just yet registered with us, you can register as a Y&I associate in our website. If you Google ICDR Young and International, you're going to find us. And in our website, you'll be able to find registration forms in English and in Spanish. And also in that website, you'll be able to find the recordings of previous webinars from this year and the previous. Also, you can join our LinkedIn group. Again, if you look in LinkedIn for ICDR Young and International, you'll be able to find us, and we'll be also posting all of our updates in that LinkedIn group. So with that, I want to give the word to Santiago, whom again, I thank very much for moderating this panel and for organizing it. Santiago, the floor is yours.
Thank you very much, Rafa. And good morning, good afternoon, or good evening to everyone. Thank you all for joining us today. I'm Santiago Peña. I'm a member of ICDR Y&I's Global Advisory Board, and I'm moderating today's webinar, which is the third of the webinar series on international construction arbitration. And the main subject of today's event are change orders and variation claims. To address these issues today, we have 4 experts in the field, which I'm going to introduce now. First, we have Fatima Balfaqeeh, who is founder and managing director of RKAH consultancy firm. She's based in Abu Dhabi and has more than 16 years of experience in supply chain management and dispute resolutions in fields such as construction, governance enforcement, in contracts, and procurement in government entities, finance, and banking. Thank you, Fatima, for being here with us today. Next is Aníbal Sabater. Aníbal is a partner of Chaffetz Lindsay in New York and has over 23 years of experience in international commercial and investment arbitration under all major rules. He's a director of the New York International Arbitration Center and immediate past member of the center's executive committee and the immediate past chair of the International Law Committee of the Association of the Bar of the City of New York. Well, of course, I think I can speak a lot of Aníbal, but thank you, Aníbal, for being here today. Next is Shona Frame. Shona is a partner of CMS based in Glasgow. Shona has been involved in construction and infrastructure dispute resolution since 1994. She provides strategic advice on management and resolution of complex construction and infrastructure disputes, acts as arbitrator and adjudicator, and is a CEDR accredited mediator. Shona's sector experience includes infrastructure, PFI projects, marine, education, and utilities. She's a fellow of the Chartered Institute of Arbitrators, an honorary fellow of the Royal Incorporation of Architects in Scotland, a CEDR accredited mediator, is on the Chartered Institute of Arbitrators, and is a CEDR commercial arbitrator and Law Society of Scotland solicitor arbitrator. Thank you very much, Shauna, for joining us today. Finally, we have Ruben Bodenheimer. Ruben is co-founder of Bodenheimer, a law firm specialized in international dispute resolution and is based in Berlin. He has acted in many domestic and international arbitration cases as both party counsel and arbitrator. Ruben has significant experience in institutional and ad hoc arbitration, dispute adjudication, and mediation. And in particular, Ruben has deep expertise in construction arbitration. He is a fellow and chartered arbitrator of the Chartered Institute of Arbitrators, professor for international law, and continues to lecture on mediation and international arbitration at different universities. Thank you, Ruben, and thank you very much, all of you, for joining us today. I think we can start now. I will start addressing the concept of changes in connection with construction disputes. And I would like to start asking Fatima, in general terms, what means a change in a construction project? Why can it lead to a dispute between the parties involved in a construction project?
Yes, hi, Santiago, and thank you for you and Rafael and ICDR for this kind invitation. And I would like to welcome everybody who's attending today with us. So today I'll be discussing more in general terms, and my colleagues on the panel will start taking you guys through more detailed information about variation and change management in a construction project. In general terms, I would say that a change or a variation event is an event that happens that results into a change in any element of the scope of the project, which might impact its time, its cost, or its quality. Now, I believe to be able to define what is a change, we should also define the elements that goes into a scope of work, because a scope of work is not only limited to specifications, as you know, or a BOQ in a construction job. So we need to identify what are the elements in general in a scope of work. In construction specifically, it can be any elements of design, management of the construction project, time, material as well, quality of the project itself and the materials used. Finances are also elements of the scope of work that should be accounted for. And of course, you know, one of the things that I'll be discussing in details, which is payments as well. And I think all of those are elements that are in a way or another should be, you know, thought about in writing a scope of work in general.
Okay, Fatima, how changes usually arise in a construction project? Is there a way to avoid them? How can we deal with that?
So in order for us to answer the question of how a variation order or a change management is arised in a project, I think we should identify our culprits. Who initiates a change management a process or a change order process? I would kindly ask Rafael to put a poll question now about who do you think our attendees you know, starts or initiates. Yeah, there you go, the question number one. What is the main cause of change? Oh no, this is the main causes. This should be, actually, you know what? Let's answer that as well. So what is the main cause of a change in a construction project? From your opinion, is it a financing issue? Is it a change in specification or scope? Is it time extension or others? So we'll just give like 60 seconds for everybody to answer very quickly.
I realize I'm discriminated. I can't participate as a co-panelist.
And you can give your view later, Ruben.
Host and panelists, we don't have any votes in.
No, nothing to say.
Presentation without representation.
Okay, I think, are we receiving answers? Can we close the poll?
Yes.
Yes, okay, perfect. Change in specification and scope. This is very interesting. Only 5% thinks financing issues is a main cause of change, and only 7% is time extension. 89%, nearly 90% of the attendees thinks it's a specification scope change. Can we, Rafael, can we put the second question in as well? Is that possible at all?
Of course.
Thank you. Okay, and who is the main instigator to a variation? From your opinion as attendees? So
is there a spelling mistake? Sorry if I jump in. It's contractor and contractor. That doesn't seem like a real choice.
It should be a why is it written twice? It's employer, contractor.
Maybe you should you want to define one or two as the employer. So
the first one is employer, the second one is contractor, and the last one is a consultant. So number one is an employer or the owner of the project.
Yep.
Thank you for that suggestion. Okay, so can we close this poll? Do we have answers?
Of course.
Okay, so 55% thinks it's the owner who initiates the change order, 27% contractor, and 18% is a consultant. I would say, and we're having some comments, immediately people are getting fired up about this topic. So it's always a very touchy topic. Contractor is the one who bears the cost initially when it comes to changes in scopes. So I would say, and allow me to share with you a combination of a study that happened. I don't know if you guys can see my screen with the slide. So this so this is a number of studies that shows who causes the variation order, and you would see that most of the studies, I would argue, who did the study from which perspective was it done also from, but you will see that most of the direction leans towards the owner initiating a variation order or change order, where they change something in specification and time and quality and all the aspects that we have discussed of what constitutes a scope of work when it comes to a construction project. The second corporate that we have is our consultant. So the design consultant, for example, they would come in and, you know, they will start finessing their design every now and then, and, you know, changing one door from one area to another, and you would see like a very nice hefty bill that comes with it because of all the man hours that they have put, because of the time and cost and material cost that is associated with that as well. The contractor, it came in third when it comes to who initiates the variation order and other elements. And I think in the past year and a half or 2 years nearly now, our favorite subject and our main topic of every webinar, you know, force majeure and, you know, pandemic and its effects on the construction industry and every other industry. Even like as an arbitrator, I can see it like coming in the forefront of whether it's in the statement of claim or a defense, defending changes in time, payment issues, change of specs, availability of material on site, and so on. So I would say that, and you would notice the dates of those studies might not reflect the reality that we're living in now. I would say that others might come in a little bit higher on the rest when it comes to people or causes of variation orders. Now, how can we, the other part of Santiago's question was, how can we avoid it? Okay, it happens, change happens, and it happens all the time. And I think we will discuss the change order process in details as well as we go on in this webinar. I would say just in general terms, proper governance when it comes to processes, contract management, payment processes, and project management processes, clear communication. And I think all of us out of experience can vouch for the number of times where we get a fact witness in an arbitration, and you would hear the lack of clear communication, whether it's from the owner to the contractor or consultant, where it really affects the whole claim when it comes to a change order. And proper document control. do not underestimate the importance of documentation when it comes to change management and how it can clear up any confusion when it comes to variation orders or claims or anything related to that.
Great, thank you, Fatima. And just to closing the issue, how the parties usually deal with changes? How can they work once this kind of changes appears?
Yeah, so there is a reason why I asked the poll question of what do you think is the main issue and the main reason or the causes of variation. Again, you will see the same studies that were done before, and you will see here the causes, and you can see all of those lists are topics that can be argued as a change management event or a change event in a construction project. So how can we deal with any of them? Again, I think the session before this one, the last one that ICDR have done was titled dispute avoidance, I believe, or it discussed dispute avoidance. And I think that is a very important element on how to deal with change. You need to avoid getting it into a place of a dispute or a claim, or if it's a claim, you need to address it immediately, discuss it openly, and have a clear process on how to deal with it. If it's because I'll speak for myself, I've seen a lot of disputes and arbitrations, especially lately when it comes to payment, and the whole thing can be resolved. As a mediator, sometimes I feel like an urge to tell the parties, this could have been mediated a long time back and resolved and closed, but because both parties kind of get into a very contentious communication pattern, then the communication fails and it blows up into a full-on dispute. So I would say explore alternative ways to dispute resolution, such as mediation, conciliation, stuff that can help maintain a healthy relationship. Try to do a preventative approach to dealing with the change management as well, through robust change management process and through robust communication with all the parties involved when it comes to a construction project. This is generally speaking, and I'm sure my colleagues will have more to add to these points.
Thank you, Fatima. Very interesting. Well, you said or spoke a little bit about change orders. I would like to move with Aníbal to talk about change orders. Aníbal, can you explain us what is a change order, how it is usually executed?
Sure. Good morning, good afternoon, good evening, everyone, and thank you very much for the invitation to be here today, Santiago and Rafael and Manuela de la Higuera, whom I believe is in the audience. Let me perhaps start on a personal note with an anecdote about ICDRY and maybe some words of encouragement. In 2015, I left Big Law to basically join Chaffetz Lindsay, the boutique that I am at, and I did so because I really had met the people that I was now joining, the people who are now my partners, at an ICDRY event back in 2005. So this is my long way of saying these events are great. Not only can you learn a lot about the law if you have good speakers, but also you can make friends. And I think it's a good thing that to remind each of you that our profession remains social, and it's good to be in touch with others and know and get to know other people. So thanks again. And now on to your question, Santiago. So what is, in essence, a change order? A change order is an amendment of a construction contract that basically documents and accounts for a change in the project, right? A couple of examples. You're a contractor, you've been requested to build a building, and you were, per the contract, per the basic engineering, you were supposed to dig a 10-meter deep foundation. But then in the course of digging and in the course of working on the ground, the owner and the contractor find out that, gee, these are sliding, these are shifting, there's a shift in the ground, these are shifting sands, if you will. The foundation should not just be 10 meters deep, it should be 15 or 20 meters deep. There's a change in there. You enter into a change order to account for that. You modify the basic and the detail engineering to correct the specification. Or you've been asked to build a road between points A and B. In the course of doing that, even though you thought that the road would be straight, turns out that you found out there's some archaeological remains in the middle of what was to be the expected road. And now you need to make a detour. The road won't be able to go straight. Now it has to have a 3-kilometer detour to avoid the archaeological remains. That means a different design. That presumably is going to mean more time, more expense in building the road. And that's typically what the change order does. It accommodates a change. It recognizes that something needs to be done differently from how it was originally contracted. And in exchange for that, typically the contractor is going to get either an extension of time, more time to do what it was supposed to do. It's going to get a contract price increase to account for the additional expense it now has to incur, or both. It's going to get both an extension of time and more money. And those, the money or the more time needed that flows from a change are usually called the impacts in construction parlance. So when there's a change, you typically end up discussing with your counterparty what the impact on the project is. What the impact is. It just a monetary impact? Is it a scheduling impact? Is it both? So typically, construction contracts contain relatively detailed provisions on how a change order is to be negotiated and entered into. When can a party, it's usually going to be the contractor, seek a change order? When can the owner mandate or require a change order? Now, something to keep in mind is that even though we're talking about the notion of order, that's in practice, the way this is documented, it's quite consensual. Order sounds more like unilateral. The owner tells a contractor how to do something differently. Sometimes that happens. Sometimes contractor is told, now you need to build 10 more kilometers of the road, and I'm hereby giving you an order that you need to abide by. But in practice, in most projects, this is a very, or should be, a consensual process. The owner tells the contractor there may be more to build than you anticipated. Let's discuss what the impacts are. Let's document that in a change order. There's also the conception frequently in discussing with colleagues that a change order usually arises out of changes imposed by the owner, and that can well be the case, but there are change orders that are agreed as a result of third-party events like force majeure. We saw that a lot with COVID-19 last year. There are now social distancing measures imposed by the government, which is a third party. There are now problems with the chain of supply, materials that need to reach site, the delays. And what do a prudent owner and a prudent contractor do? They typically sit down and they negotiate how that impacts the project and whether an extension of time or a contract price increase are warranted. So there can be different sources for the change order. And I'm also talking about change orders entered into by the owner and the contractor, but you can also have change orders in subcontracts. You can have a contractor enter into a change order with a subcontractor. Just to finish this, I know we're in an arbitration forum. Typically, if you are an arbitration lawyer, you're not going to be involved in the drafting of the change order. Very often, the parties discuss the change orders themselves without lawyer involvement. Sometimes, to the extent outside lawyers are brought in, it's just to it's from the commercial, the corporate perspective. It's relatively unusual unless there's a lot of foresight or maybe some sort of seed planting for a potential dispute. It's unusual for an arbitration lawyer to be involved in what's just the sheer drafting of a change order.
Okay, Aníbal, and from that point of view, from the point of view of an arbitration lawyer, suppose the parties did not hear Fatima and they didn't make a good management of the dispute and they are now in arbitration. As an arbitration lawyer, what do you look for in a change order? How can it impact your case?
So typically, change orders come up in two ways in arbitration cases. I mean, the many other shapes and forms in which they may come up, but typically it's one of these two. One, it's the situation that you have when the contractor sought change orders that the owner denied. The contractor claims, well, you really changed the specs here. I ended up doing more than or something different from what I was expected to do, and I need to be compensated for that. Either having more money or more time to complete the project, or both. And you, owner, unlawfully denied the change order request. And then the owner appears and says, no, I rightly denied it because the work you were being asked to do was really within your scope of work. There was no change. Or you haven't substantiated the order, meaning you haven't really shown that you incurred more expenses or that this impacted your schedule. Or there's a timeliness or call it gateway issue with the way you submitted the change order request. Like the contract required that you submit a change order request within 15 days, and turns out you filed it like 9 months after the event. So those are typically when you have disputes on whether a change order request should be granted or not. Typically, the debate between the parties in an arbitration focuses on one or more of these three issues. Is the change order timely, properly submitted? Is it properly substantiated? Does it really show that the contractor was impacted? And is there entitlement to the change? And then number three, scoping issues. If you want to follow the legally logical sequence of analysis, it would be gatekeeping issues, threshold, timeliness issues, scope issues. Was there really a change in the scope of the work? And then entitlement and substantiation issues. Those are typically the three issues. Those are the disputes that arise out of whether a change order should have been granted. There's a second category of relatively common change order disputes, which is scoping disputes, pure scoping disputes. We agreed to amend the contract, so there's not really a dispute on whether or not the change order should be granted. It was granted. There's a dispute as to what it says. And you were really required. We entered into a change order pursuant to which you were expected to do all the interconnection of the plant, the power generation plant, to the national grid. That was agreed in the change order. But we're now disputing whether building a substation was part of the scope of work that you were required to do within the change order or not. So you in that case, you're disputing what was negotiated, what was discussed in the order. These types of disputes, they're not different from a pure scoping dispute with respect to a change order request. And then there are other, I mean, I think those are the two most frequent change order disputes that you will see in practice, but there are many others. I mean, sometimes you see arguments that a change order, even though really signed, may not have been validly executed. Or you see owners claiming that they signed change orders under duress because the contractor was threatening to walk away from the project. Is that right or not? Or one party trying to walk away from a change order, arguing that there was a problem because I really agreed to pay you more than I should have agreed to pay to you. I was misled into believing this would be a very expensive additional work, but in fact, the additional work you were asked to do was not that expensive. So the order should be reduced. You sometimes also see orders along those lines.
Thank you, Aníbal. And is it possible to a change have occurred without a written change order? And how should project documents be interpreted in order to define whether a change has occurred?
That's the million-dollar question in many disputes. Now, most contracts, so typically construction contracts are quite detailed. The parties know this is an important project, it's a complicated project, and they go to relatively great lengths to make sure that everything is properly documented, and they're very clear rules of the road. Those are codified. So change orders are usually expected to be in writing. That's what most construction contracts require, and they're usually subject to relatively detailed negotiation and execution requirements. But sometimes happens that someone says, the contractor usually will be on the side of arguing against the owner that, well, I really ended up doing more work. I really ended up having to, I don't know, construction of the plant, lay down fiber optic for the communications at the plant, which was not in the scope of work. I did that. It cost me like $3 extra million, and it's a change you requested. And I did it, nice guy that I was. We never documented the order in writing, but based on a course of conduct, it's quite obvious that you requested the change and I agreed to it, and now you have to pay me for the extra money that I incurred in completing this additional scope of work. The short answer is it depends a lot on how the contract is drafted, what the applicable law says, and how conclusive the course of conduct between the parties is. There's some contracts, especially in the common law tradition, that quite explicitly disclaim non-written change orders, and that quite explicitly say that any amendments to the construction contract will only be valid if entered into in writing. Typically, if you're in a New York law or an English law case, typically that's going to be enforced, and typically that's going to prevent there from being a non-written change order. The civil law tradition can be different, can be somewhat more flexible than that, taking into account parties' intentions and other extraneous elements. So I've been going on for a long while, and I haven't really given you a conclusive answer. So, but I hope at least I gave the main guidelines.
Excellent, Aníbal. Thank you very much. You were very clear. And this last issue maybe leads me to ask now Shauna about the notices, the concept of notices. Can you explain us, Shauna, what are notices?
Hello there. Yes, absolutely. So notices are often found as part of the contractual machinery, requiring one party to notify the other one that something has happened. So they're a way of communicating something which has got a contractual consequence in a more formal way, setting them aside from just normal day-to-day correspondence. So they're quite often required in the context of claims for extension of time and claims for additional payment. And those claims in turn often arise because of the instruction of changes or variations to the contracts. But the requirement for notices certainly can be broader than just notices of additional time and money claims. For example, termination, not the subject of this webinar, but termination is an area where notices are an important part of the process. So sometimes contracts have quite prescriptive requirements for notices in terms of content, the information that's to be included in them, and timescales. And I think we'll probably come on to those shortly.
Okay, and why do they matter on construction disputes? Why are notices relevant in this kind of disputes?
Well, I think for disputes lawyers particularly, they're something which tends to be an issue often. So I think there's really two aspects to contractual notices, and the first is a project management, and the second relates to claims and time bars. So looking at the project management aspects, part of the reason to have the contractual notices is they create a flag as the contract is progressing that certain things are happening, that an event's taken place that might cause delay or that might increase the cost of the project. So they can be a really useful early warning system, and that allows the parties then to address the issue and maybe take action to mitigate the consequences of it during the project while it's still possible to do that. So in the context of changes or variations, it might be that having received a notice saying that a change order will cost time and money, the parties might decide not to, or the employer or owner might decide not to instruct the change after all, or they might do it in a different way, which is less time consuming or less expensive. So in that respect, they can be really quite a useful project management tool. Some contracts require notices to be issued at the point when a contractor believes the contract is about to be in delay or that additional cost is starting to be incurred, whether that's a ground for claim or not. And sometimes the contract requirement is to issue a notice as soon as reasonably practicable or whenever it becomes reasonably apparent. Some have a time limit of a number of days. But in general, the principle on the project management aspect of claims is that the notices are issued around the time of the event happening, rather than storing it up until much later when it comes as a surprise. So looking at the second aspect, the claims aspect of notices, there's a real interaction between notices and claims. So in some contracts, the requirement to give a notice acts as a condition precedent or a precondition to entitlement to an extension of time or to additional payment. That depends on the drafting of the particular clause, but it's not unusual to have time bars associated with notices. So, for example, the FIDIC contract has a provision that if a party considers that it's entitled to additional payment or to extension of time, then they have to send a notice within 28 days of becoming aware of the event that gives rise to the entitlement, or 28 days of the date that they should have become aware. If they don't, then the party has no entitlement to additional time and money. And there's a similar provision in the NEC contracts. So these contracts are widely used around the world, but in NEC, there's a requirement to notify a compensation event. There's a time limit for the contractor to do that. And if they don't do it, then there's no entitlement to a change to the completion date or a change to the prices. So you can see from those two examples from standard form contracts that there can be very serious consequences for a party, often the contractor, if they don't get their notices in on time, and it certainly can bar a claim completely.
Okay, Shona, and can I ask you what happens if the notice is not does not comply with all the formalistic issues? How can be addressed? How can you address it?
Well, I think as a dispute lawyer, or in fact lawyers as advisors to parties more generally, there's a number of commonly encountered issues. And as you say, the formulaic issues around content of notices and a number of other aspects are really important. So what I thought might be useful at this stage is to go through some of the common pitfalls that we see. And the most common one of those is the validity of the notice. Assuming that one has been issued at all, then the next thing that we would look at is validity of that notice. And that's particularly important, of course, if the notice is a precondition to entitlement. So there's no general rule that you can apply as to whether a notice is valid or not. That's always going to depend on what the contract requires. So if you're asked to draft a notice for a client, my advice is always to be pedantic, be very particular about what the contract requires and make sure that you follow every step of that. And that really means examining the clause very carefully and making sure that you pick up every requirement of the clause. If you're on the other side and you're challenging validity of a notice, I would do exactly the same and go through every aspect. And one of the tips that I tell my team is to use the Rudyard Kipling's Honest Serving Men. Some of you might know the poem that comes from, but it's very good advice. And for all drafting, I find if you ask yourself the questions, who, why, what, when, where, and how, you will draft any clause properly. So in the context of notices, I would suggest checking the contract to see in that order who is to serve the notice. So some clauses require the party to serve, and some allow for the agent of the party to do it, so their lawyer or the contract administrator or another third party. And sometimes a contract will have different provisions for different sorts of notice. So it's always worth checking the clause that you're serving a notice under to make sure that the correct party is serving it and that it's going to the correct party. The second is why. Why is the notice being served? What's the event that triggered the notice? That might be the variation being instructed or another event, which is a contractual trigger for additional payment or extension of time or something else. So it's quite often worth just referring to the clause number that the notice is issued under and being very clear in the heading of the letter that it's a notice under that clause. And that puts it beyond doubt that this is the intention of the communication. Then the next one is what? What is the notice supposed to say? And does the contract have provisions about content of the notice? So some clauses are very brief and general. For example, they might just say, describe the event that gave rise to the claim. That gives you quite an open invitation to include any content that describes that event. Other clauses are very particular about the content. So for example, some clauses say, tell us about the circumstances of the delay, the cause of the delay, the particulars of the effect of the delay on future activities, and an estimate of the effect on completion date. So you can't assume what the notice is supposed to cover. Again, go back to the clause and check what's there. When is the notice to be served? Are there time limits? So on timing, I gave a couple of examples from the FIDIC and NEC contracts, and the disputes lawyers will have spotted the language that I mentioned about the deadline running from the date of awareness, or the date that the parties should have been aware. Now that obviously brings with it an element of subjectivity in terms of what is the start date. If it's a for information notice, so one of these notices that are for the purpose of project management, then it might not matter too much because they don't tend to have such prescriptive deadlines. But if it's a notice which is a condition precedent to entitlement, then they're likely to be more prescriptive about timing. So if you're drafting a notice and you want, then you would want to explore with your client what the date of awareness was. And if you think it seems to be quite slow, like the event happened and it's quite a long time before the client became aware of the event, then explore that and find out why. You know, it can be that people are not on top of their programming, or they notice additional costs later if they're not keeping a close eye on the budget. But it's sometimes necessary to have that explanation so that you can explain why the date of awareness is what it is and why the notice is on time rather than too late. If you're on the receiving end of a notice and advising a client about validity, then you'll want to scrutinise that timing and see if there is an argument that the notice is actually time barred because it came too late and that the start date of awareness was an earlier date than is said. So two more, I'll take them together. How is the notice to be served? So that's any particular method of service, and where is it to be served? And by that, I'm talking about whether the contract has provision for an address for service. So quite often there's a separate communications clause in contracts, and that sets out these things, where and how to serve a notice. They might allow a service to be by post, sometimes still by fax. I don't even know where my fax machine is in the office anymore, but there are still provisions allowing notice to be served by fax or email. And sometimes they set out the address for service and the individual people it's to be addressed to. So quite often these clauses are ignored for regular communications, and the parties just do that by email, or they have a portal set up for the project. And where that's the case, the parties are in the habit of communicating in that way, and they might assume that a notice can be served in the same way. But it's always worth checking the communications clause, and if there's any doubt, make sure that you serve in the way that the contract has said, and just follow the strict requirements about service. Quite often what we find is these clauses are entered into at the beginning of the project, obviously. And so the individual people named, or the addresses, have moved on. And by the time the notice is being served, they're out of date. And that raises a question. Your contract tells you to serve on this address or this person, but you know that it's not the right place because they've moved office or the person has left and there's someone new in post. But again, this is about validity of service and doing it in accordance with the contract. And my opinion is that even if the details are outdated, I would serve the way the contract says on those people, but also to the new and updated ones. And then you've done both, you've strictly complied with the contract, and you've made sure that the person who should receive it has received it, and it just avoids having the argument later whether it was properly done. The principle behind it is you want to be able to evidence compliance with the contract and that the person who should be receiving the notice actually gets it. So on that topic, proof of delivery is an important aspect, whether you're serving it by post, in person, or by email. Just think about how you're going to evidence that the person received it, in case that's ever put in doubt. And the final point on admin aspects is look at any deemed delivery dates. So sometimes a notice sent by post, the contract will say that it's deemed to arrive 48 hours after posting, unless you can prove earlier delivery. So if you're up against it on a time limit, your client comes to see you on day 20 and the notice has to be done on day 21, sending it in the post with a deemed delivery of 48 hours later won't work. And so you need to be careful about deemed delivery dates and just make sure that it's still done in time, do it in person or whatever. So the idea with all of these questions, asking the who, what, why, where, when, how, is to close off the avenues for rejecting notices on a technicality so that you can get to the heart of the dispute, which is what's the substance of the entitlement that the notice is trying to trigger.
Very clear, Shona. Thank you very much. We are a bit short of time, but just to finish the topic, you have already mentioned some of them. What are the commonly encountered issues regarding notices?
Sorry, I think I've probably covered those, and just looking at the clock, I should probably let Ruben come in with the fourth topic. Thank you.
Okay, thank you, Shona. Okay, let's move then with Ruben. Thank you again, Ruben, for being here and wait for us. We would like to address with you the issue regarding the dispute boards. Can you explain us what is a dispute board and how a DB is usually formed?
Yes, of course, Santiago. Thank you very much. And it was not about waiting. It was a mere pleasure listening to my fellow panelists. I took some notes as well. And as much as I'm fed up of virtual meetings, I must say, and I can join in, Aníbal, if ICDR YNI calls, then of course I stand ready. Tell me, Santiago, before I get into the topic, how much time do we have left?
It's okay. I believe we're supposed to have 5 minutes, but it's okay, Ruben. You can, we can
extend as long as I want. That's yes. Great to hear.
Of course.
Well, okay, let's jump into the topic. Well, what is a dispute board? I mean, just go one step back, and that is look at the topic. It's changes and variations. You could ask the question, why do we talk about dispute boards now? And I think the link is not that obvious on first sight, but on second very much, because it is the changes, it is the variations that come hand in hand with a lot of trouble and with a lot of costs. And I can start by just drawing this picture from a project I was involved with, and that was the significant expansion of a North African airport. So now think about that. The contractor realizes that the indications for steel and concrete in the main pillars of the terminal are not sufficient. So the owner says, okay, make it as you deem fit. It is done. And then we have the situation, as already somehow described by Aníbal and Fatima as well. He says, okay, I want to get a payment for this. Now, this is not very spectacular, but what is spectacular is that at this very case, we're talking about a construction site where at the peak time, 5,000 people were working there at the same time. So what happens if you start to argue about this? At one point, the contractor will say, listen, you either pay me, or we're not talking about this 150,000 bucks, but we talk about, I will stop continuing to work. And then we have every week a 7-digit number that accumulates if I withdraw 5,000 people from the construction site, right? So wouldn't it be wonderful to find a solution to avoid exactly such a horror scenario? And this is where dispute boards kick in. It is the idea of implementing in the end a conflict resolution mechanism, which is implemented at ideally at the very beginning of a project, which consists, as we will talk in a minute, of 1 to more, in many cases 3 members, which are invited to constantly follow the process of such a project and stand ready to give their opinion, render a decision or a recommendation on any dispute that might arise. And the charming, brilliant idea behind this invention is to avoid an escalation in an ongoing project, but to deal with issues and conflicts when they arise. That is a dispute board. And how is it formed? That was your question as well. Well, I said already, ideally, at the very early stage, a lot of its charm is obtained from the idea that you have individuals involved who do know the project from the very first minute. And that I invite all my co-panelists to object if they have different experience. But the fascinating thing is that regardless of the binding or non-binding character of such a decision or a recommendation, the percentage of decisions accepted by both parties is extraordinarily high, on the simple basis that, different than in an arbitration or any other dispute mechanism, these individuals do know the project from the scratch. So their recommendation is based on an almost unique knowledge about the dispute, which of course, in addition, enables them to give in very short notice decisions, which also reduces costs significantly. So normally it is constituted in the same classical way as you probably all have seen and do frequently when it comes to arbitration. Each party appoints 1 dispute board member, and they agree on a chairman together. Now, this might be known to all of you as well. So let me just briefly address some ideas on this, what I have seen in practice. And this is a very charming opportunity to make these boards even more efficient. So in some Eastern European large infrastructure projects, Aníbal mentioned one when he was talking about highway construction. There's a new approach to, for example, appoint 6 members for the DRB, which then operate during the entire lifetime of the project with different expertise, different specialities. So when a dispute arises, you can compose the tribunal of the respective ideal specialists. Isn't that amazing? But because at the same time, you have a group of, in my example, 6 individuals who are familiar with the project from the very first day. Needless to say, in smaller projects, you can think about 1. And there are a lot of variations which allow you to do so, because you're not as tight as in an arbitration tribunal, which has to follow, of course, much more regulations in light of potential enforceability of such an award. Last half sentence is, the charming thing is as well, You probably all know this and you all take this into consideration when it comes to arbitration proceedings. But specifically in dispute review boards, it's a very charming approach to not only limit your selection to lawyers, but take on board experienced experts, which mostly could be engineers, architects, or depending on the specific project, experts in the field most likely to be needed.
Thank you, Ruben. And do dispute boards exist in all construction projects? Are DBs recommended for any construction project or are only advisable for some particular projects?
Well, you don't have the global concept of mandatory dispute boards. I would say there is an increasing tendency to consider dispute boards in projects. Historically, and I don't want to bore you with this, I think you can find dispute board routes in the United States for the typical reason, because it's a country where you have a high incentive to consider about more cost-efficient measures of settling disputes. And I think the boom has started in the 90s, where first the World Bank incorporated the concept of dispute boards in all their infrastructure projects, followed then, which of course today goes kind of hand in hand, by FIDIC, which also incorporate the concept of dispute boards for their clauses and terms. Most known, the FIDIC Red Book article or clause 20 and following there. But it doesn't exist in all projects. I would even say I recommend you to consider the installation of a dispute board, not only in almost all construction projects, but to think about the installation in other industries. And I dare say it's something, we are running out of time, but it's something where I think it could add value in any contractual relationship where the cornerstones are similar like in a construction project. So it lasts over a long period of time. Parties have a complex issue at hand. They need to cooperate for an ongoing basis, and an interruption of the project would lead to significantly more costs. If you have these cornerstones fulfilled, and we easily can think about joint ventures, development agreements, the building of ships, which you could say is just construction, and many more, where I think people are still lacking awareness of the beauty and the advantages of a possible dispute board installation.
Great, very interesting, Ruben. And just to finish this, can you explain us how it works? The DB's decision is a final decision. Can the parties appeal it? How does it work in general terms?
Yes, I'm aware that we already extended, and this is a question I would say I'd love to speak about this one for an hour itself, but trying to keep it very brief. It's a typical lawyer's answer, and that is it depends. It depends on how you structure and design the dispute board. The classical approach would be that dispute board decisions are binding. So parties do have to comply with the decision, but they are not final. That means you can appeal against such a decision. Normally, and subject, of course, to the dispute resolution mechanism agreed between the parties by initiating arbitration proceedings. But even when doing so, even when not being in agreement with the decision, you normally have to comply with it. So it is actually the classical concept of shifting the insolvency risk, right? It's the concept of pay now and argue later, which serves for very good reasons greatly to the advantage of mostly the contractor, who otherwise has to run after its money for services and works performed, and not very seldom sees insolvency before it sees the payments that it was going after. You can redesign this, and there are a lot of aspects that need to be carefully observed, and that is to which extent and when do you is the obtaining of a dispute review board or dispute board decision actually a mandatory requirement to initiate further proceedings, right? But this would be my answer in short.
Thank you, Ruben. I think we should wrap it now. Thank you very, very much, all of you. We have received some questions. I'm sorry, we are very extended in time, but I would like to remind you all that this event will be posted on the ICDR website, so you can all see this webinar. And I don't know, Rafa, if you want to say some final remarks, some final words.
Sure. No, this has been a very interesting discussion, and again, I want to thank all the panelists for their insights and everyone who attended. Again, the webinar will be posted in our website very shortly, so you can listen to it again if you missed any part. And with that, again, thank you all very much, and have a great rest of your day. Bye now. Thank you all.
Thank you very much to all of you.
Bye.
Bye-bye.
Thank you. Bye.
Bye. Thank you very much.